What you're saying is that all the Trump administration is doing now, they don't have to employ any kind of exotic type of cudgels. They just come along and say, guess what? You've been violating the Civil Rights Act. You're violating Title IX. And so the universities suddenly realize that the Trump administration is holding the strong cards. And this is why, I mean, I understand Harvard is pushing back, but they're negotiating behind the scenes. And Columbia, as you say, has already, to a large degree, capitulated.
Yeah, that's absolutely correct. So even before the Students for Fair Admissions decision, which officially deemed affirmative action in admissions to be unconstitutional or and also in violation of the Civil Rights Act, the Civil Rights Act made very clear that discrimination in hiring is not allowed. That's both for public and private entities. So even if you're a private university, this applies to you as an employer. And while there are some very small exceptional cases where employers who have historically discriminated, like the employer has actually gone out and said, we're not going to hire people of a certain race, unless you have a situation like that needs to be remediated in a court basically can determine that that's what happened, it's pretty much just across the board illegal to say we're going to hire based on race. We're going to give special preferences based on race. We're going to give you 10 extra percentage points in your application if you're an underrepresented minority. All of those things, they weren't just made illegal a couple years ago with the Supreme Court's decision. Those have been illegal for a long time. And so, there are two implications to that. On one hand, that means that, well, I mean, it's pretty much an open secret that universities have been violating the law for a long time. So if somebody comes along and actually wants to enforce the law and make universities account for the way they violated the law, then universities are in a pretty bad place. But also, universities have been violating the law for a long time with total impunity. They're used to a situation where they simply do not have to actually follow these laws. To the extent it's so bad that a lot of professors and administrators actually don't know what the law entails. And you'll see, when I get public records, I often see just evidence of confusion. Some people know what is actually legally required and what is, legally prohibited. And some people have no idea. And so they'll just openly state things like, oh, I don't want to hire white men for sure, which in a court could get them in a lot of trouble. And you're right, for the most part, universities just have not been taken to court on this. And it's really hard to find plaintiffs. It's really hard for somebody who has spent 12 years of their lives getting to the point where they can apply to a professor position, then say, yeah, I'm going to go sue the university and pretty much blacklist myself. But the one entity that can take universities to court without that kind of power imbalance, actually with the power imbalance going a little bit in the other direction, is the federal government. And with the federal government actually wanting to take action, this is what we get. The Columbia decision, ultimately, they're paying $200 million to settle things. And I think that, that seems pretty reasonable. Even, left-leaning professors like Larry Summers, the former president of Harvard, former Clinton administration, just big name in Democratic politics. He said that decision or the Columbia deal was great. He said that this is a good model for how to reform things. And I think that we're going to see universities across the country doing something like this. I don't think it'll be long before Harvard takes a step towards, settling this long, drawn-out negotiation process.